Greetings. What it do, lineage? What go on? This is your brother Chief, man, with another video, with another one. Tune in, get your seatbelt tightens. Let's do this. Let me make sure I have audio on Facebook so we could get started. While I'm doing that, I would like to take the time to acknowledge our ancestors. All right, each and every one of them. Let's do it. Let me make sure I have audio. We have audio on Facebook, so we're good to go. For those of you who are catching the live, man, do me a favor, let me know what territory you're in. I will give you a shout out. If you're catching the live a little later, it's all good. Either way, go ahead and share the information. What up, D Sago? What's up, my brother? It's been a minute, man. Good to know that you're still here, wealthy, physically wealthy, brother. All right, so we're about to get into a little something. Do me a favor, share the information. We got Dallas, Texas in the building. Who else do we have? If you don't mind, if you're not subscribed to the channel, whether it's on Facebook or YouTube, subscribe to the channel, hit the notification bell so you don't miss the lives. On Facebook, follow me so you get the notifications. As you know, I'm about the business. I always come and give you the real, right? So in this video, we're going to talk about, protecting yourself in law. Certain ways you could protect yourself, all right? Because a lot of people get jammed up for minor things, right? And they end up doing time because of the way the system is set up. Like I said before, the system is perfect. The system is set up to be a cash cow, and going to jail is a business. You feel me? Allegedly. I have to put that in there because we know how they do, right? Don't believe anything that I say, please, because in the word believe is the word lie. So I'm only coming here with information that's researchable. Do your due diligence and learn how to protect yourself. So the first thing we're going to do is we are going to start with the Constitution. We're going to start with the Sixth Amendment, right? And certain criteria that are actually in there for real. Now, when it comes to the Constitution, it gets a little bit tricky, because dealing with the color of law, and what I mean by that is people who are under color of law, generally the Constitution don't protect them, and that's a fact, right? I'm going to repeat that again. Generally under the color of law, the Constitution don't really protect people, all right? Just put it that way, because these courts that they have out here in all these cities and all these counties, the majority of them, if not all of them, they are not 3-article courts. All right, they're de facto courts. Those judges in those courts, they're literally magistrates. You know what I'm saying? And that's just what it is. Okay, it's a business. It's a day-to-day business. It's a business for profit, and it's really that simple. It has an EIN number, like every other state, like any state. Each state has an EIN, and that's facts. So when it's all said and done, you're doing business. It's all about contracts. Okay, but regardless of what the situation is, you still have to learn to protect yourself. And a lot of people don't know how to protect themselves. So we are going to go into a couple of things. Let us first start with the Sixth Amendment. All right, and let's dive in. Let me go ahead and share my screen. Here we are. Now, this information may help somebody. It may not help somebody. If it's not for you, it's okay. If it's for you, then, go ahead, embrace it, do your research, share the information. You might help out a young brother or a sister, prevent them from getting into a situation. So here we are. The Sixth Amendment of the United States Constitution protects the rights of the accused in a criminal prosecution. All right. Right to a speedy trial and public trial. That's in the Constitution. Right to a speedy trial and public trial. So anytime there is a trial, we have to assume that it's public. So those courts are not private courts. Those courts are public courts. So when you go into the building, they cannot tell you, oh, well, you can't videotape in here, you can't do this and you can't do that. Like, it's a public. Who's the public? You are the public. So if therefore the court is the public and it's a public trial, you have a right to videotape it. If you want to go live, you should be able to go live. You see, when you truly do things and look at the letter of the law, these people are violating a lot of the laws that's in the Constitution and that's in case law. It says right to a speedy trial. So if you get into a situation, they shouldn't have you sitting in jail. And the question remains, well, what is the length of time that's considered a speedy trial? So that's something that you'll have to look into doing your own due diligence. But I'm just giving you the basics, the letter of the law from a face value, right to a speedy trial. And it's not just one component, it's two components, right? And means an addition or a multiplication, right? So it has to be two components. Otherwise, your rights are being violated. So right to a speedy trial and public trial. The accused has the right to a fair trial that is held within a reasonable time. All these things must be constituted for you to know how to protect your rights. Right to an impartial jury. The accused has the right to a jury of their peers. Now, that word here, the peers, is very key. And I'm going to break that down for y'all. Because most people get into situations, like I said, and they don't know how to protect their rights. You have rights. Even if you're being governed under color of law, if you know how to maneuver, those rights apply to you. It is really that simple. Next, right to be informed of the accusation. Let's read. The accused has the right to know the nature and cause of the charges against them. Next, right to confront the witness. The accused has the right to cross-examine the witnesses testifying against them. Next, the right to a compulsory process. The accused has the right to obtain a witness in their favor. Next, right to assist of counsel. The accused has the right to a competent attorney who will zealously advocate for them. So we're going to break a lot of that down right now. Okay, we're going to break a lot of that down. So let's go back here. I want to go back to we already broke down the right to a speedy trial, right to an impartial jury. But how can you have an impartial jury, okay, when the jury is not a jury of your peers? When it says, it emphatically says within the Constitution, you have a right to a jury of your peers. Most people don't know what that means. And this is where I come in. I'm going to break that down for y'all because a lot of your children, your cousins, your brothers, your friends, or people are going to jail because they don't comprehend these things. Nobody's teaching it to them. So let us get into that. Let us go into the Black's Law Dictionary and look at what does it really mean when they use that word peer in there. Okay, I'm going to stop sharing this, and we're going to go ahead and share the next screen. Give me 1 second, and we'll come back to where we just left off. Red Rising on 9. Greetings. Okay. Now, like I said, this may not be for you, but it's information that's going to protect you and protect your children. So I would say it's for you. All right. Let's go into Black's Law Dictionary, the 2nd edition. And we're going to look at the definition, the legal definition of peers. The legal definition of peers, okay, in the Black's Law Dictionary. It says in feudal law, and remember when I did the video, I gave you the comparison or the difference between a feudal system, okay, and a system that is opposite of that, as in just sanguine. You feel me? But let us read. In a feudal law, the vassals of lord who sat in a court as judges of their co-vassals and were called peers. Let's read that again. The vassals of lords. So you see who the peers. What does it mean? You are not a lord, so or at least you have not claimed your lordship, so that doesn't apply to you. So that's why you are not being tried by a jury of your peers, because that's what it applied to in law. Let's read this again. Greetings, Ebony Royal. Welcome to the build. Let's read that very carefully again. So when you read the Constitution and you are standing for your right and you question those things, you have to make sure that you let them know that you know what you're talking about. And the Constitution does say you have a right to a jury of your peers. What does it mean? This is what it means. The vassals of a lord who sat in a court as judges of their co-vassals. So it was between judges, okay? It was between judges, people of the cloth, so to speak, okay? People of that association, people of that society, the legal society, and were called peers as being each other's equals. You are supposed to be judged by your equals as a lord or of the same condition. The nobility of Great Britain being the lords, temporal, having seats in parliament, and including dukes, marquises, earls, viscounts, and barons, equals those who are the man's equal in rank and station. These being the meaning in the phrase trial by jury of peers, of his peers. So my brothers and sisters, when they pull you into this court and they pull a jury, guess what? Those are not your peers. Those people are not your peers. I'm only here to teach you. Do what you want with the information. So right there alone, you have a situation. Right there alone, you have a situation. Now, in that case, if you are not a lord, okay, you are not part of that society, then if we are going to look at it as the way they want to interpret them saying a jury of your peers, then it's supposed to be people of your same status, your same nationality, your same identity, okay, your ethnic group in a sense. So by that definition alone, you did not get a proper trial by that definition alone, because these people are not your peers. Even if they live in the same community with you, they're not your peers. They are not your people. So they have no right to be the jury in any case against you, period, point blank. But you see, it's about community, right? I have to keep bringing back community in the conversation, because how do you alone enforce that when you have nobody backing you, when you have no community standing behind you or with you? You feel me? So then you're alone. So you just go with what they say. But no, that's not what it's supposed to be. All right? And that's why I do what I do. That's why I'm so passionate about what I do. Too many of our people are sitting in jail and all those rights were violated. They were not protected because they did not know their rights. And as a people coming together as a community, we could step up and challenge all these things and get many of our brothers and sisters out of jails. We have a right to do that. The right to impartial jury. The mere fact that they are not your peers, that's alone is impartiality alone. So that disqualifies them to be even in that position. All right, cool. Let us go to another significant one. And let me blow that up some more, because I really want you to see this. Right to confront the witness. The accused has a right to cross-examine the witness testifying against them. Now, this could be very technical, and I'm going to explain to you what that means. Most of the times, when you get arrested and you go to court, right? When you look at the summons, 99% of the times, if not 100% of the times, it's the state. The state is the one bringing the case against you. The state is the plaintiff and you are the defendant. So if you have a right, if the Constitution says I have a right to cross-examine, the accuser, the person that's testifying against me, then why aren't you questioning the state? The prosecutor, the DA is not the state. They cannot speak for the state. So therefore, the state cannot prosecute you. I keep telling y'all, man, don't play with me. Okay, I'm going to repeat that. The state is not a living entity. And if the law says I have a right to face my accuser, then my question is to the judge, press the record and make sure that the state, he or she, the state, because that's the question I'm going to ask. Who is my accuser? And if they say it's the state, well, I'm going to ask them, do me a favor, please. Can you bring Mr. or Mrs. State of New York? That's exactly what I'm going to say. Can you, Your Honor, my honor, can you bring Mr. or Mrs. New York before the court, press the record, because I would like to face my accuser? He cannot tell me, well, the prosecutor, no, the prosecutor is a third party. The prosecutor is not the one accusing me. And if he's the one accusing me, then let the record show that he has to show how I did him wrong and not the state. You see the technicality? But nobody's teaching you that. I'm going to repeat that. You have a right to face your accuser. The accuser, 100% of the times, unless it's a personal lawsuit, is the state. So therefore, I'm going to ask the judge or request of the judge to make sure that the state, as in the state of New York, I'm asking for Mr. or Mrs. New York to come before the court, press the record, and state his or her claim, or otherwise forever hold his or her peace. The judge cannot turn around and tell me what is the prosecutor. It says on the summons, the state. The prosecutor is not the state, so he cannot be the witness against me. My next question would be, was he a first-hand witness? If he wasn't, then I call for dismissal. Know your rights, my brothers and sisters. Now, I'm not telling you this to go out there violating people and hurting people and harming people. I'm just teaching you these things so when you're put in a position where you did not commit a crime, but they are telling you commit a crime because it was some type of statute or code or ordinance, that's a difference. Know your rights. The right to confront your accuser. All right? Let us rock. And of course, you have a right to counsel. And you could bring one of your own peers to counsel. You could do that. You have every right to do that. You feel me? All right. Let us proceed. Now that you know what peer means, let us proceed. And I'm also going to show you something. I don't know if they have it in your state, but I can show it to you. All right. Let me show you another thing that may work for you. There's a law called next friend law. Let me explain to you what that means. I don't know if it's in the state that you in, but that's generally a rule of law in many states, okay? The next friend is a person who represents someone else in court when that person is unable to appear on their own behalf. Next friends are usually family members or other people who care about the person they are helping. They are not parties to the case, but instead act as an agent of the court to protect the rights of the person they represent. You see what I'm saying? So you don't need a lawyer or an attorney. And I'll tell you why. In a few, you did. But if you have somebody who's versed, then that falls under the next friend law because you are incompetent. You did? Keep that in mind. All right. So just want to share that little bit of jewel with you. Let us go to the next joint. So we did peers. Let's close that out. Let us go to the next one about the judges. About the judges. Here we go. The U.S. Constitution's 6th Amendment and 14th Amendment guarantees a fair trial, which requires an impartial judge. That is the law. The law also requires judges to disqualify themselves from the proceeding where their impartiality might be questioned. So if you have reason enough to question the partiality of the judge, you could request that the judge recuse himself from the case. Well, how can you conclude that a judge is impartial? Is partial, pardon me. For one, a judge is partial if he's the one, trying to put you on trial. That's not his job. His job is not to prosecute. He is a referee. And a referee's job is to watch both sides. It is really that simple. But however, how can he be impartial when he's working for the same state that's accusing you, for the same state that's prosecuting you? You see, you have to know these things. And that's why it's imperative that we come together and stand as a community and challenge these things. Where is our own courts? Because the judge works for the same system that's prosecuting you. The prosecutor works for the same system that's prosecuting you. And the lawyer or attorney work for the same system that's prosecuting you. Explain to me how you're going to win that case. Explain that to me. So 99% of the judges, okay, in my opinion, that's my opinion, they are partial based on the interpretation I just gave you. Okay, because it says this code requires judges to perform their duties fairly, impartially, and diligently. It also requires judges to avoid impropriety and appearance of impropriety. The section 20, title 28, U.S. Code, section 445. The law requires judges to disqualify themselves from proceedings where their impartiality might be reasonably questioned. You feel me? That is the law, and there's a code for that. So based on the judge's behavior, certain type of questions, and you see it's more leading towards the prosecution and not just standing to be a referee, okay, then you can make a determination whether the judge is being partial or not. And then you could invoke this code, Title 28 UFC, Section 455. All right, let's move on. Let's move on. Let's move on. Let's move on. Here's another thing. Here's another one. The Fifth Amendment of the United States Constitution protects people from being forced to testify against themselves. That's why, okay, whenever you're read your rights, you shut the hell up. They tell you. You have a right to remain silent. You have a right to remain silent. Because why? Anything you say can and will be used against you in the court of law. All right. You cannot be forced to testify against your own self. They have to Miranda you, so to speak. And no, Miranda is not a girl. Okay. If they don't Miranda you, and they don't have proof of that, because it's your word against theirs, they have to have proof. It has to be on record. That's a dismissal right here. If they're going to force you to testify against yourself, that's violating your rights. Okay, let's go to the next one. Let us look at the allegiance of attorneys, their first allegiance. According to legal ethics, an attorney first allegiance is generally considered to be the legal system, meaning their primary duty is to uphold the integrity of the law and administer justice, even when it may sometimes conflict with their client's interests. That's interesting. An attorney's number one priority and allegiance is to the legal system. And the legal system is not a lawful system, because law is not legal and legal is not law. I'm just giving you the facts. I'm just giving you the facts. Typical example. And I'm not advocating that you do this, but I'm gonna give you an example. If you're traveling in your automobile, right, and you get to a red light and you stop and you look both ways, and then you make a right or you go straight or you make a left, and there was no accident, everything was clear, you was not creating no type of danger, or you was not endangering anybody, right? That is not unlawful. That's not unlawful. However, it's illegal. You get what I'm saying? Let me say that again. If you get to a red light and there's no other sign saying, well, you could go left or you could go right or you could go straight. No sign saying that. However, you stopped at the red light and you look to your left, you look to your right, and there is no traffic, no pedestrian, everything is good, and you took the light and you went through the light, a red light, right? A police officer stops you. Now check this out. What you just did is not unlawful, but it's illegal because it's an ordinance. It's a statute. You violated an ordinance and a statute. Now, I'm not advocating you do these things. That's not what I'm saying. I'm showing you a difference in something being lawful and something being legal. It is illegal, but it's not unlawful. Okay, it is a crime in a legal system, but in a lawful system, it's not a crime because you did not harm anybody. You did not damage anybody's property. You did not injure anybody. So you have not committed a crime in a lawful system under common law. But in the legal system, it is a crime. And these same attorneys work for that legal system, and their number one allegiance is to the legal system. What does it say? Even if it conflicts with their client's interests. So you see the distinction slightly between lawful and legal. Legal is of law, but law is not of legal. Hope that makes sense. Let us proceed and go to the next one. All right. Let me see. There's a law in New York. Let me see that to prevent. Now, there's a law in New York. I don't know if it's in your state, whatever the case is, but let me show it to you. Okay. That an unmarked car cannot pull you over during a traffic stop. All right. Check this out. It's a bill in New York, and the bill number is I think it's S289. All right. And it says, title of bill, an act to amend the vehicle and traffic law in relation to the prohibition or prohibiting the use of unmarked police vehicles The purpose: to prevent motorists from being victimized by criminals impersonating police officers by providing that only marked cars, police vehicles, may be used to pull over motorists for alleged violations of vehicle and traffic law. The summary of the provision: Section 1 adds a new Section 1102A-A to the vehicle and traffic law to prohibit the use of unmarked police cars to routinely stop or apprehend operators of motor vehicles for certain violations. I'm gonna give you an example. I was traveling and I was actually going down Bedford Avenue and I made a left on Park Avenue. Now, the light was about to change. Now, I caught the yellow light. It was amber. I caught the yellow light, right? And I made that left. I got pulled over, all right? As soon as I made the left, I heard whoop, 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 sirens on. Pulled over, whatever the case is, that. Long story short, it was an unmarked car. I ate that up in court. Because first off, I didn't know you was a police officer, all right? You pulled me over. There was no emergency, and you used your emergency lights. What was the emergency? A minor traffic so-called violation is not an emergency. You're not supposed to put on your emergency lights. And you was in an unmarked car. I ate that up. You see what I'm saying? So you have to know how to protect yourself, man. Little things like that could prevent you from going to jail. And once again, I'm not sharing that information with you so you could go out here wilding out. That's not what it means. I'm not doing that for that purpose, but I'm just tired of too many of our people going to jail for all these minor things that they could have avoided. Showing you how to protect yourself. That's what this is all about. All right. Now let us get into the major joint now. That comes above all: jurisdiction. Jurisdiction. That is the number one. That is the biggest monkey in the courtroom. Okay? Whenever you challenge jurisdiction, they cannot have court. Period. I don't care what type of court it is. Challenge jurisdiction. Let's read that. When jurisdiction is challenged in a legal case, the defendant argues that the court does not have the legal authority to hear the case. Here are the conditions. Typically, due to issues relating to the geographic location of the parties. The geographic location of the parties. We'll kind of break it down in a few. I'm just going to read it out. The subject matter of the dispute, or the defendant's connection to the jurisdiction, and the burden falls on the court to determine if it has the power to proceed with the case. If it does not, the case will be dismissed. A defendant can raise this challenge at any point in the litigation process, often through a motion to dismiss based on the lack of jurisdiction. I don't care if the case hasn't started. I don't care if the case is in the middle of in a heat and it's in the middle. I don't care if the case is about to end. As long as you challenge jurisdiction, it got to stop. Now, what are we going to do? We are going to go point by point, and we are going to break down the conditions and the criteria of dismissing or motioning for dismissal based on jurisdiction. It says, when jurisdiction is challenged in a legal case, the defendant argues that the court does not have the legal authority to hear the case, typically due to issues related to what? Geographic location of the parties. Number one, geographic location is very, 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 very important, right? Because the people who are trying the case, they are not of this land. That is a conflict based on status. So geographic location deals with status. You feel me? Somebody from Europe should not be able to try an original American. That's why they give us all these different titles of Black, African American, and Negro, and all these things. Because why? It ties us to the legal system. So status is number one. It challenges the geographic location. If you want to prosecute me or try me, go back to Europe. Period, point blank. You see, you get what I'm saying? But those things cannot be effective unless we come together as a collective. Can you imagine one individual, challenging jurisdiction solely on status and geographical location, even though he or she is doing the right thing, how effective is it going to be when they're by themselves? How effective is it going to be when they're by themselves? But when there's a community behind you, we all in the court, what's going to happen? Our law stands. You feel me? Our law stands because that deals with status. Only a God could judge a God. They are gods and lords in Europe. This is our land, so we are the lords of this land. That's where now it's called a jury by your peers, because it deals with the lords of that same community, of that same vassal, of that same society. You see how I brought it back into 360? In fact, a 720, brought it all the way back around. So jurisdiction must be challenged. Well, of course, the subject matter, it depends on the situation. You dig? So that could be challenged. The defendant connection to the jurisdiction. I am not in a European court. Or, you know what I'm saying? If you feel like it's a European court, then that's not where that your jurisdiction lies. I am not European. I'm not a descendant of European. I would like to be tried before a jury of my peers, and I am an American, whether you want to say American Indian or original American, whatever you want to say. If you feel you're more, if you feel you're Israelite, listen, that's where you invoke that. So you could be tried by your peers of Israelites or a peer of Moors or peers of American Indians. You feel me? And the burden falls on the court to determine if it has the power to proceed with the case or not. Now, most likely, if you're in there by yourself, you're not going to have that type of success. But if you have your peers with you, they may not be on the jury, but they're in the court, then, hey, they know what's going on. That's why I keep preaching and talking and teaching about community coming together. Am I my brother's keeper? Yes. Am I my sister's keeper? Yes. Jurisdiction is number one. Status. What is the status of the prosecutor? What is the status of the judge? What is the status of the clerk? Are they indigenous to this land? Are they original indigenous to this land? If they are not, that's dismissal. You don't belong in there. Let them try their people. They're not supposed to be trying us. That's why so many of our people are in jail, because they don't know who they are. They don't know how to protect themselves. Period, point blank. All right? So, with that being said, if you want a little more on status and, situations such as what we're discussing here, this is the book I suggest you go to the website and you get a copy of that book. All right, it's called Newsflash. Everyone's a slave unless. You go to the website. It's in the description. The website, myniji.com. Get a copy of that book. The title of the book is Newsflash. Everyone's a slave unless. Newsflash, everyone's a slave unless, breaking down about the law, breaking down about how we got enslaved, on paper, in commercial, in maritime. So that's the book for you. Definitely want that in your arsenal. All right. For those of you who want the copy of Gene Insists to Reevaluation, that talks about American history, about the people who came here in 1492, who they were and all that, then you get the book one of Gene Insists to Reevaluation. All right. You could either go to the website and get that, or what you could do is you could send an email. My email is in the link below, and that's only for Gene Insists to Reevaluation. You get the book for free. You just send me an email. Hey, Chief, I need the book, free book, Gene Insists to Reevaluation, whatever the case is, with your phone number and your name, and I will email you back, and I'll tell you how to pay for the shipping, and you get the book for free. All right. That concludes the lesson on this. Greetings, Goddess Empress. I hope I give you guys some information that could help you navigate this legal system. This legal system is not a lawful system. It's a legal system. But the number one thing, even before you talk about rights and all of that, the number one thing you want to deal with, that's why I went over it last, is jurisdiction. Jurisdiction is number one. If jurisdiction is challenged, nothing could happen. Okay, if jurisdiction is challenged, nothing could happen. And even with an attorney, you could also let the attorney know that you have your own counsel, which is you're invoking what's, like I said, the next friend law, where you bring your own peer to stand in before the court to stand on your behalf, even with counsel, if you so choose. Because the number one allegiance these attorneys have is to the legal system, even if it conflicts with their client's best interests. And don't believe anything that I say. Go all over the United States and look at the jails and see the majority of the people that's in there. We could get them out if enough of us come together and challenge those things. We could get all of that stuff dismissed, and we could, and even possibly having those people file a lawsuit, because a lot of them in there, because their rights were violated. Their rights were violated, period. And excuse of the law, ignorance of the law is no excuse. It goes on both sides. If you know that you're violating somebody's rights, then you should not proceed because you know the law. But you choose to be ignorant and ignore the law and yet still prosecute innocent people or people who have not committed crimes. Or put it that way, they have not broken the law because they committed a crime, but they have not broken the law because anything could be criminalized. So we have to be very mindful with that word crime and what it means, because everything is a crime. If you spit on the road, that's a crime in certain places. If you pee on the road, that's a crime in certain places. If you jaywalk, that's a crime in certain places. But that's not breaking the law, because you did not harm anybody, you did not injure anybody, you did not defraud anybody. The state is not a living man or woman. That's the only time you break the law, on the common law. And we are living in a common law land. It's in the Constitution. It's in the Supreme Court. It's common law. So invoke your common law. Point blank. So digest on the information I just gave you. I know a lot of you are reflecting now, thinking in your head, oh my goodness, my brother could have did that. My sister could, in fact, I could have done that. Yes, you could have. Each one teach one, man. We got to look out for each other. We got to stand with and for each other. It's the only way we're going to make this work. No other way. But that's the only way. And that's why I take the time to do it and give you the information all day if I can. I don't ask you for a dime. I don't ask you for a donation. I don't do none of that. Even if I ask you to get the books is for your benefit. You know, you see what I'm saying? You're not doing me a favor. I'm giving it to you. You see what I'm saying? So the point I'm making is I'm really, really, truly putting my all into you. That's what I'm saying, bottom line. So go over the information again, right? Do your due diligence. I'm just opening up your mind to the information. You could do more studies and you'll learn more things and become sharp with it. There's no need every time you hear whoop, 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 or every time you see the flashing lights, your heart stop. Because you think they're going to pull you over, and you know you have not done anything wrong. But it's just because of the way we were programmed, and it's been embedded in us. When we see those flashing lights and we hear the whoop whoop, we should stop breathing. That's not me. In fact, when I hear the whoop whoops and I see the sirens, I smile, because I already know I'm always ready. I'm always ready. That's why they always throw me out of the court. They always throw me out, kick me out of the court. Get out of my court. I mean, hey, I could hit them back with, it's not yours, it's mine. I'm the people. It's a public court, and I'm the public. But I don't even waste my time. I just walk out, because I already know. They know that I know, and I know that they know that I know. You feel me? That's it. As long as I've not harmed somebody, damaged somebody, defraud somebody, then I have not broken any law. I have not done any wrong. There's a difference between a crime and doing wrong. The question is, what have I done wrong? That is the question you have to ask. What have I done wrong? Don't tell me I broke this law. It's not a law. Or I broke this code. It's not a law. What have I done wrong? And the man or woman that's trying to prosecute me or making these accusations, let them come before the court, press the record, state their name. State their name and make their accusation. State their claim. If they cannot do that, then guess what? They need to fall back. And the state of New York, the state of Georgia, the state of Florida, none of them could press the record and talk. So therefore, they cannot be my accuser. And the prosecutor cannot represent them. I did not do anything to the prosecutor. Let him bring the receipts. Let him show the receipts. And that's how you know when the judge is being partial or impartial. Because if he's not going to give you your W on that, then you know he's being impartial. You feel me? Then he's being partial, pardon me. He's being partial. So you invoke that code to make sure that he recuse himself. It's a win-win. But like I said, the number one factor is jurisdiction. What's your status, Your Honor? What's your status, prosecutor? And don't tell me you're from New York or you're from Delaware or you're from none. What's your status? In fact, what's your origin? Where are your ancestors from? Europe, Asia? Okay, well, you cannot try me. You feel me? You are not in my jurisdiction and I'm not in yours. I'm an American. This is my land. I'm indigenous to this land. You are not. See, once we know these things and we stand on those things together, it's going to be a little more challenging individually because you don't have no support. But when they know you have a community, it works. I have seen it with my own eyes. And I've told that story over and over again with the Jewish people. When they walk into the prison and get their children, even before their children get fingerprinted, even before there's a court, they go in the prison and get their children. All right, then. All right, so we'll talk a little later. Just wanted to share a little bit of information with you. And enjoy the rest of your continuation, all right? We'll talk soon. Thank you.